Welcome to the Big Law Business Report, where big law meets big business. I'm your host, Brian Brown. In the studio today, I've got Phill Hampton, intellectual property attorney with the law firm of Haynes Boone. Phill, thanks for joining me today.
Well, thank you, Brian.
So, Phill, you're an intellectual property attorney. So let's talk a little bit about some of the challenges that some of your clients see, or some of the things that you face working with your clients as far as their intellectual property is concerned. But before we go too deeply, let's just touch a little bit on what intellectual property is. I mean, is that patents, is that copyrights? What's intellectual property, Phill?
Intellectual property is the term that was coined probably in the mid-'80s that encompasses patents, trademarks, copyrights, and trade secrets, and sometimes now even computer law.
Gotcha. So, Phill, I know you work with a wide variety of companies, particularly international companies. I know in some of the conversations that we have, we talk about an organization called the ITC. Is that the right organization?
Yes, the International Trade Commission. It's a agency of the federal government that actually decides some patent cases under its authority to stop unfair competition by foreign entities.
So when you talk about unfair competition by foreign entities, what do you mean by that?
Well, as the statute defines unfair competition to include patent infringement, trademark infringement, or any type of intellectual property infringement.
Got you. So if I have a situation where I know you've done some work with medical devices companies, so I've come up what I believe is someone has developed a knee replacement technology, or maybe a stent or a catheter, and I take this and say, wow, this is pretty cool, and I make one just like it, but the quality maybe isn't there, but my price points are substantially lower. Would that be a scenario where if you were defending the company who made the original piece of equipment, would that be something that would end up in the ITC if I was an international company, or is it something totally different?
Well, it has to be something that's being imported into the United States.
Okay, so my product I made, I want to bring to the U.S.
If you're trying to import it into the U.S., the U.S. patent holder could file a complaint with the International Trade Commission.
Okay.
The advantage of filing a complaint in the International Trade Commission is that you basically have an entire patent infringement case in 9 months. And
Whoa.
generally they take a lot longer than 9 months.
So how do they get this done in 9 months?
Well, I mean, instead of a lot of things in the federal rules give you 30 days to respond, in the ITC you have 10 days to respond.
Wow. That's amazing. So to go back to this example I give, so I'm that company that has made this knockoff type of product. I'm trying to bring it into the United States. The company who makes the original product, I mean, couldn't they potentially say, well, hey, this knockoff product is going to hurt my business in the United States? What does the ITC do for them? Is it just, somebody infringed on the patent, or maybe the potential damages to that original equipment manufacturer's market share in the U.S.?
Well, see, that's the thing. The International Trade Commission, the patent owner cannot get any money damages. However, it's only 9 months, and what they can get if they prevail is a nationwide exclusion order, which means that the product cannot be imported into the United States at all by anyone.
Wow.
So that's often even more powerful than actually getting money damages.
Got you. So if I'm producing this product in some country, right? I'm producing it in Southeast Asia. Then I say, well, you know what? Okay, I got kind of shut down in Southeast Asia. I mean, I'm going to produce it in South America, or maybe I'm going to try to produce it in, parts of Europe. So basically, what you're saying is this inclusion prevents this from happening altogether. It doesn't matter where I'm going to try to bring the product in the United States. Basically, it can't come in, or where it made in the other state.
It basically can't come in. Of course, the maker of the infringing product could try to modify it a little bit and try to say it's not the same, but generally that's not very successful.
Got you. Okay, so is Border Protection involved with are there other government agencies involved with this?
Yes, ICE is involved. Basically the customs service
right
would be involved, and they're very good at, once it gets listed as a product that can't come in the United States, Customs is very good about keeping that product out.
Right. So I know you can't mention any client names, of course, But have you, I take it in the years that you've been practicing law, which of course have been numerous, the gray hair. So, I'm sorry, that means wisdom, right? So, but in the years you've been practiced, you've seen these cases. Can you talk a little bit about some of these scenarios?
Well, the general scenario is, again, a foreign producer or some foreign entity manufacturing. They're often trying to import it through a U.S. subsidiary or something. So in the International Trade Commission, you often sue not only the manufacturer but the importer. Now, interestingly, sometimes the importer, especially if it's a different company, will sometimes say, hey, I'm going to stop importing and let the manufacturer and the patent holder fight it out because I don't want to be,
Caught up in this, right?
and I don't want to have to pay attorney's fees.
Right.
I mean, the problem with the International Trade Commission, because it operates so quickly and you're basically doing an entire patent infringement case, you are probably looking at about $2 million
Wow.
in 12 or 13 month expenditure. So it's high stakes patent infringement litigation.
Well, but I guess, I just kind of think intuitively that, yeah, $2 million on the surface probably seems like a lot of money. But if you're in a market that generates $250 million, $500 million of business for you, and you know that not only my speculation would be that this knockoff other product cannot, I would imagine, not only have an influence on the market share, but could it potentially sort of hurt your brand as well? Because people may begin to associate the knockoff product with your product?
Well, occasionally it would if there was a trademark issue involved also.
Gotcha.
In that which would implicate the brand.
Gotcha.
But generally, it's most people don't know who makes the catheter that's put in their heart stent.
Sure,
They just
of course.
don't.
That's true.
So branding doesn't usually come in, but more and more trademark cases are now going before the ITC because, again, trademarks are becoming very important and big business in the trademark area.
Got you. Well, Phill, this is absolutely an unbelievably fascinating topic, and clearly, as stated previously, your wealth of knowledge is somewhat limitless. But I look forward to, Phill, having you come back on our show, and let's continue our discussion about the many other aspects of intellectual property law.
I look forward to it, Brian.
Thank you so much.
Thank you.
We'll be right back. Here you go.
Okay.